And coming our way next, we shall find ourselves in the warm company of Miss Audrey Forshey. Miss Forshey is a RE/MAX Realtor and a very special advisor to RE/MAX Realty. Today on her set, we will meet an attorney whom you're quite familiar with as he appears on the Capitol Forum each week for the past many moons. His good name is Attorney Ramesh Khurana, who's the Chief Attorney and Counselor at Law from the Khurana Law Firm located in Gaithersburg, Maryland. Let's hear all that Attorney Khurana and Ms. Forshey have to offer to us as far as owning the property is concerned.
Hello friends, thank you for joining us again today on Real Estate Today. Today, I'm Audrey Forshey from RE/MAX Realty Services located in Rockville, Maryland, and I work in the Maryland area, Montgomery County mostly. And today our guest is Ramesh Khurana. He is an attorney in Maryland and in Washington, D.C. He specializes in a lot of real estate transactions, so I've asked him to help us with some questions pertaining to real estate today. So thank you for joining me today. It's so nice to see you.
Thank you, Audrey. Thank you for inviting me.
Oh, of course. I was at a settlement earlier today, and the buyers were signing the papers, and they had a lot of questions about what they were signing. And one of the questions that they had was, what kind of a deed would they be signing today? There are different kinds of deeds in the state of Maryland, and so I thought it would be a good subject for Mr. Khurana to speak to us about today. So can you please explain to us the different types of deeds and what they mean to the consumer?
First of all, congratulations. You completed settlement this morning.
Yes.
Very good.
Very
and then
good.
You had to come to the studio for this recording.
Yes.
I know.
It's a good day.
I agree with you that any settlement or closing process for the property is very stressful. And I know a professional like you who works diligently with the clients tries to make it very comfortable and stress-free. So I think the topic which we are going to discuss, like what types of deeds are there, and because you have to educate your clients so that they are fully prepared before even they come to the settlement table.
We hope that they know,
right?
right?
That's right. And you know, when we are talking about deeds in Maryland state, there are three types of deeds, and one is the special warranty. Under the special warranty, basically the conveyor or the owner, who's called the seller at the settlement table,
Right.
he says that I'm specially warranting that during the period I have been the owner of this property. I haven't done anything wrong personally with the property.
Okay.
So he doesn't promise anything before he owned the property.
Okay.
And he's saying that I have personally not done any wrong. So this is what is provided for under the special warranty deed. Then we have another type of deed, which is a general warranty deed. Under the general warranty, Audrey, you know, he says, the seller says that I am warranting that nothing wrong has happened right from the beginning till today.
Okay.
Of course, he is not warranting anything for future
Right.
after the property is sold, but right from the beginning, going back 60 years, 100 years, nothing wrong has happened.
Okay.
This is what he warrants. So that is called the general warranty deed. And I'm pretty sure during your real estate transaction, you must have heard about another term, which is called the quitclaim deed.
Yes.
And the quitclaim deed usually is prepared to correct some errors or mistakes in the deeds, or there may be some other special situations when quitclaim would be recommended by the settlement attorney.
Okay.
So these are basically three types of deeds. Under quitclaim deed, by the way, the conveyor or the transferor, he says, I'm not sure about the title of my property. I'm not giving you any assurance at all.
Okay.
So we usually say under the quitclaim, he cannot give anything more than what he already got.
Okay.
So this is the simple version of three types of deeds.
So if I'm a buyer and I'm going to buy a home in Maryland and I have the choice between a special warranty deed and a general warranty deed, which one is best for me? Like what do I feel the most comfortable buying a home with.
So then general warranty deed should be your option.
Okay.
Yeah.
Okay.
So that you have a warranty from the seller
Okay.
right from the beginning to today.
Okay.
Yeah.
So, and I have a lot of clients that do estate planning, you know, they put their homes in trusts and all that sort of stuff. If they put their home in a trust, does it change the deed? Is a deed different if it's in a trust?
I think this is a very good question, Audrey. You know, basically people think once they have done their estate planning, you know, let's say under the estate planning they have prepared a will, they have prepared an irrevocable trust, revocable trust, and durable power of attorney and the advanced medical directive. They think that probably they have taken care of their real estate. The answer is sometimes wrong. The reason is whatever you have put forth in your deed, that will govern how this property is going to be transferred to your heirs.
Okay.
You know, let's say if the property is under joint tenancy, so both these joint tenants, they are basically owning the property at the same time. This is called the concurrent ownership.
Okay.
And if one person dies, the property goes to the other person who is surviving.
Okay.
Right?
So, right.
So that point we have to keep in mind. So I would say, while you are titling the property at the time of settlement or at the time of purchase of your property, you are doing a kind of estate planning.
Okay.
It's a kind of tool, like how you want to convey your property to your heir or next person.
Okay, so that then brings up another issue is when you buy the property, we usually get three choices when we buy property. There's the tenants by the entirety, which is husband and wife. It's a married couple, right? And that means that if something happens to one, does the property automatically go to the other one? Is that right?
You explained it just right.
Okay.
Yes, when we are talking about the tenants by the entirety, this is available only for the married couple.
Okay.
Only for the husband and wife.
Okay.
Otherwise, it's out of question.
Okay.
So, under the tenants by the entirety, if the husband dies, I'm just giving an example, the property will automatically or by an operation of law will go to the wife.
With no probate or anything like that?
Absolutely nothing is
Okay.
required.
Okay.
And another thing, if the property is under tenants by the entirety, you don't have to have another deed if one of the two spouses dies. Let us say husband has died and wife has become the sole owner of the property, and she keeps on sitting on this deed or on property. After 5 years of her husband's death, she decides to sell off the property. At that point of time, she is required just to show the death certificate of her husband.
Okay.
And she will be able to convey the property just under her signatures.
Okay.
Because
Okay.
she became the sole owner as a result of operation of law. But sometimes tenancy by the entirety is dissolved by an agreement, like both the husband and wife can agree, or if divorce takes place.
Oh, okay.
Yeah.
Okay.
Then if the two parties are divorced, it's no longer tenants by the entirety.
Okay.
Another interesting thing you might have heard that under tenants by the entirety, the couple's home is fully protected against the creditors.
Yes.
So long as lien is due to one of the two.
Right.
You know, in fact, there is only one exception. There was a case law which was decided in 2002, United States versus Kraft,
Okay.
whereby it was held that if there is a federal tax lien on the property, then even if it is a tenants by the entirety property, it will get attached, which should be IRS lien.
Yes.
Otherwise, any other type of lien doesn't get attached to the property.
Yeah, so it has a lot more protection, the tenants by the
that's
entirety.
Right. That's why it's highly recommended, especially in the state of Maryland. And my understanding is that 25 states in the United States, they recognize the concepts of tenants by the entirety.
Okay.
But since we are confining our discussion to the state of Maryland, so it's very important to understand for the husband and wife, if they are buying the property, why not to have the tenants by the entirety? Other thing, if the tenants by the entirety words are missing, but it says husband and wife, then the presumption is the property is tenants by the entirety.
Okay. Okay.
You know, whenever people come to me for the estate planning, I tell them, bring your deed for the property. The reason is, I would like to look at the deed.
Yes.
Whether it is tenants by the entirety or not. Sometimes settlement is done by a settlement company which is not owned by a lawyer, you
Yes,
know, because
yes.
that person is a settlement agent approved by the Maryland Insurance Administration and following those licensing issues. So I want to make sure that the couple has the tenants by the entirety option on the
Okay.
deed. Yeah.
And then the other, if you know, I have a lot of single people that buy homes from me, and they own the property as sole owners. Is that right? So, what kind of what is that title called?
Right. You know, if a person is a sole owner, so just one name would appear.
Right.
But sometimes what happens is that 2 or 3 people, they come together.
Correct.
And they want to own the property, and they do not want the joint ownership. I
Right.
think this is what you meant. And if there is a joint, there's no joint ownership, and people want to have their individual rights, let us say A, B, and C.
Yes.
3 people come together to buy one residential property. So A, B, and C, they are basically tenants in common.
Okay.
So each one of them holds his or her share individually.
Okay.
And there is no concurrent ownership in a way, because each one is owning his or her own share. And the share percentages, those may be different as well. Like somebody may own 30%, other person may own 25%, and 45% third person.
Right. I see
So-
that with investors sometimes.
Yes, that's more common, more common. So one person can even sell his or her share in the property to, let's say, in our example, person D. Person D comes and becomes tenants in common
Right.
along with B and C. So likewise, and the purpose of this kind of tenancy is, if let's say A dies, so it goes to the legal heirs of A.
So if A passes away,
Right.
then A will leave his share of the property to his heirs. It doesn't go to the surviving owners,
exactly,
right?
exactly,
Okay.
yeah.
Okay. All right. Well, that's
Yeah.
good to know. There is one though that they can do. Is it tenants in common with the right of survivorship or something like that?
Yeah, I would like to say one thing about the joint tenancy, that there are 4 unities of interest.
Okay.
And this is very important to understand. Now, first of all, interest. Like there has to be a uniform interest in the property. Under tenancy in common, we had one example whereby people's ownership was in different percentages, but not here. Like if there are 3 people, each one of them has 33.33.
Correct.
So
Oh.
to make it 100%, right?
Right.
Right. And similarly, possession. Now, all the owners of the property should possess the property. Our title should be vested at the same time. So there is a title, then there is a time, which I said same time, that interest and possession. So all these 4 unities of interest should be there in case of joint tenancy.
Okay.
So, Audrey, I think with this, we have covered quite a lot about the types of deeds and types of tenancies. Of course, I wish we would have more time to
Yes.
discuss more.
Maybe
but
another
your
time.
questions were very pertinent. I am pretty sure the audience must have been immensely benefited by our discussion. And if we get a chance some other day, probably we will talk in more details.
Okay.
Thank you very much
you.
for inviting me.
Thank you, of course. Thank you for your support. Thank you very much. We'll see you next time on World of Real Estate.